Hello and welcome to Criminal Justice in a Nutshell. My name is Dr. John Fisher, and today's subject of Criminal Justice in a Nutshell is capital trials. More specifically, we're going to be talking about the Sixth Amendment. We're going to be talking about some of the protections capital defendants, those defendants that are facing the death penalty, some of the protections that they have in some of the court cases that went to the Supreme Court to help ensure that we have super due process. There's a lot of talk running around right now about how, the application of the death penalty is racist at its core. Whether it is or not, I don't know if that's up to me to decide today, but this is what I do know, and this is what we're going to talk about, and that is super due process. And some of the things that are established and created, let me take a pause. I'm recording today from the Cahoma RV Park in Cahoma, Texas. It's basically right off the interstate, so there should be a whole lot of truck and traffic noise going back and forth. I'm in the edge of the Permian Basin, and right now the Permian Basin is the center of the world. It is the center of the world because of the oil industry and the oil field and the fracking, and most of the oil and most of the world's fuel and plastics and chemicals are taken from right here in the Permian Basin in Texas. As I said, it is the center of the economic world. It's no longer New York, it's out here in the middle of the desert. So please excuse the traffic. There is a lot of it. There's no place for me to go to escape the world. And if you look behind me, let me move this up. There's some other campers here. Basically, this is what's called in this area a man camp. It's just people working in the oil fields have got a campsite. I'm here in the Big Spring area for the 4th of July to visit my grandchildren and my son. But anyway, let's get back to it. There are 10,000 homicides each and every year in the United States. There's a lot of talk about how the United States has the most people incarcerated in the world, and we do. We are ranked number one in incarcerations in the world, but we also are number one in homicides. We've got 10,000 homicides every single year. About a little over 3,300 of those, right at 1/3 of these homicides go unsolved forever. They're never solved. So today we're going to be focusing on, like I said, super due process and the Sixth Amendment, how the Sixth Amendment applies to capital defense. And there's a couple cases, there's going to be several cases I'm going to talk about. But specifically we're going to talk about Strickland versus Washington and Brady versus Maryland. Strickland versus Washington talks about AIC, which is inadequate. Hold on a second. Inadequate assistance of counsel, meaning that the lawyer didn't do his job. There were some cases that I've been reviewing where the defense attorney fell asleep at the table. Okay, the prosecutor, and one of these cases is on a podcast I listen to. Or used to listen to, so I'm not going to give its name because, I guess it's called Truth and Justice is the podcast. And they're talking about a Texas case about the murder of Jaime Melgar. They prosecuted, convicted, and sentenced his wife for his murder. And part of the appeals process is that the attorney fell asleep at the table. Not a very good outlook for that attorney. And Strickland versus Washington approaches and addresses all of those things. The second case we're going to look at is very important, and that is Brady versus Maryland. Brady versus Maryland covers disclosure of evidence. In my court systems classes, I call it Rule 16. Because it is Rule 16. Rule 16 requires that, and the Sixth Amendment requires, that a defendant has all of the evidence against them in order for them to create a defense so that they can defend the charges that have been brought against them. So we're going to look at those. But before we get into Strickland, Washington, let's start looking at where this started. And it started in about 2000 with Williams versus Taylor. Williams versus Taylor confirmed, it established that, or reconfirmed, that if a defendant cannot afford an attorney, one will be appointed to him. We already know that from Miranda. But Williams versus Taylor turned around and said, you know, in the death penalty cases, there's very, very few people that can afford a death penalty defense. So in response to not being able to afford a death penalty response, what we're going to do is ensure that, let's see if I can, there we go. We're going to ensure, excuse me, that defendant has an attorney, okay, and that attorney is paid for by the state. But because this is a death penalty, there are more stipulations. And one of that is that you need to have two qualified defense attorneys, two death penalty qualified attorneys to hear your case. Stephen Bright stated that the death penalty is not reserved for the worst criminals in the world, just for the defendants with the worst attorneys and the worst lawyers. And that's because the defense attorneys are put in a really bad light. They're already starting at a disadvantage. Evidence shows and studies show that the average prosecution spends $1.5 million on a death penalty case. Whereas prior to Williams v. Taylor, your average defense attorney for a death penalty case was paid $613. What kind of attorney are you going to get to take a death penalty case from voir dire through sentencing on $613? A study in 2000, and that was back in the 80s and 90s, the average attorney was making $613. In 2000, a new study was created. This was after, in conjunction with Williams v. Taylor, and they learned that the average death penalty attorney was making $29,500 for a death penalty case. Okay, but that's still not helping anything, is it? Because if the defense is getting paid $29,000 and the prosecution has $1.5 million at their disposal to convict an individual and send them to death row, the defense is at a disadvantage. And geez, the traffic's getting really loud. But anyway, it just makes it impossible for a jury to side with the defendant. And that's not working because all of a sudden, I don't know. I like it better here. Okay, anyway. I guess also at this point I'm going to need to qualify that I don't know how to pronounce a lot of these names, and I might mispronounce them. Some of these names, like this next case, it's an Oklahoma case, and it's Ake. A-K-A. A-K-E. Ake, Aki. I don't know how to pronounce his name. But the court stated that the Constitution entitles the raw materials that are integral to building an effective defense. They addressed this monetary discrepancy, and they said that the state must pay for the defense of an individual that can't afford it, and it allows for auxiliary services. So now the attorney's getting paid $29,000 for his time, and he doesn't need to use that $29,000 to pay for other people. Okay, so this looks into services that are reasonably necessary. Mitigation specialists, and we're going to get back to the mitigation specialists in a little bit because they're important. And I know we've already talked about mitigation earlier in the semester, but I am here we're going to talk about it some more. To pay for a psychologist or psychiatrist in order to determine mental health issues and mental health issues. So Terry Williams came to the court, and Terry Williams, Terry Williams came to court, and he brought to the Supreme Court the argument of ineffective assistance of counsel. The lawyers didn't do any investigation into the mitigation and into the mitigation circumstances of Terry Williams. And if they would have, it's believed that the jury would not have sentenced him to trial. Terry Williams was raised by an alcoholic parents. He was severely abused, physically abused, emotionally abused, sexually abused. And there was a lot of things that were going on in his past, in his childhood, that mitigated his attitudes and behaviors. If mental health issues are not being treated or addressed, they're going to get worse until you're going to find yourself as a murderer. And because those investigations and because those mitigating circumstances showed prejudice in that without that information, the jury didn't have a whole picture, and they would have, it's believed that the jury would not have sent him to death row. So the courts had to go back, and they ordered that a new sentencing hearing be conducted. So Strickland versus Washington is what we opened with as the important case. That is the leading case in defenses for ineffective counsel. The court ruled that the counsel has a duty to make reasonable investigations or to make a reasonable decisions that makes particular investigations unnecessary. Okay, Strickland's ineffective assistance to counsel had two claims: deficiency and prejudice. Deficiency is that the counsel's performance had to be objectively unreasonable, and that scrutiny must be highly differential. Is the actions and the behavior of the attorney what caused this case to find a conviction and which caused this case to end up on death row? And then the second was showing prejudice. And what we mean by prejudice is that was there a reasonable probability that the outcome of the case would have been different if the attorney would have provided and presented this information to the jury? Would the jury have come to a different decision? And if it has, that means that the information, it was prejudiced, or the withholding and the failure of the attorney was prejudiced against the defendant, and a new trial should be set forth. And we'll get to some qualifiers onto that here in a little bit. Okay, so Wiggins versus Smith, the question was the reasonability of the presented or investigated mitigation. And what they said was, or they confirmed, or they added on to Strickland, in saying that it's not just the job of the attorney as he's presenting his case, but also as he investigated the case and he prepared for trial. Did the attorney do and perform his due diligence? If he did not perform his due diligence, he was considered an inadequate counsel. Okay, Rumpia versus Beard stated that an investigation of mitigation circumstances should also include information to rebut the state's aggravating case. Okay, so not only are you supposed to be looking for mitigating circumstances, for example, and I shared this case about a Texas defendant. He killed his girlfriend, stabbed her 47 times, filleted her, cut her out her spine, left her hiding didn't left her hiding. She put her in a closet with a loaf of bread and number 10 coffee can, and left her there to die, if he didn't already believe that she was dead. These are all aggravating circumstances. So it's up to the defense to investigate information that would rebut those aggravating claims. Okay, so why did he do these things? What caused this defendant to do all of these horrible things to show that he's a heinous criminal? Okay, well, and that comes in with the mitigating circumstances. Did he have a mental health issue? Was he under the influence of drugs and alcohol? Did he believe, or was he taking out his anger upon his girlfriend on a paternal subject or a step parent that abused him in that same exact way? What kind of things were in the background? So the defense attorney is also required to look for information to rebut the aggravating circumstances. Porter versus McCullum, the court said that Porter's lawyers had never represented a death penalty punishment phase. So he wasn't qualified to be a death penalty attorney. Okay? And because of his failures, he failed to investigate mitigating circumstances, and this prejudiced the jury, so Porter got a new trial. And now what they're doing is you have to have two attorneys. Okay, before you can sit lead chair in a death penalty case, you have to sit second chair on several. You have to have, before you can become the lead attorney, you have to have a lot of experience as a second chair or as that second attorney in a death penalty case. And then you move forward and you move up. Sears versus Upton, the counsel failed to uncover extensive evidence of childhood trauma. Sears was severely beaten, and there was a lot of things that happened to Sears, and the defense attorney never brought any of that up in the sentencing phase. So it went back for resentencing. Okay, and it's important, and the mitigation system or for the punishment phase is extremely important in this world. And I am at 17 minutes. Wow. I try not to let these videos go over 20 minutes. I'll try not to let them go over 15 minutes. So I'm going to have a part 2 of this, and what we're going to be doing is talking about prosecutorial misconduct and the Brady case. So this is Dr. Fisher with Criminal Justice in a Nutshell. This has been the episode of Mitigating Circumstances in Death Penalty Cases.